Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. Sitting with me on the panel for the case that we will be hearing today on this Zoom argument are Justice Sabita Singh and Justice Marguerite Grant. The case that we will be hearing this morning is case number 2020-P1293, the Commonwealth versus Elijah Judge. The defendant's appeal. Mr. Levin, you may begin.
Thank you, Your Honor. May it please the court, Patrick Levin on behalf of Elijah Judge. This is a conditional guilty plea appeal of a motion to suppress. And I briefed two reasons why the motion should have been allowed. I'd like to begin, if I may, with the dog sniff and circle back to the Terry stop issue, if there's still time at the end. So the Commonwealth, where it relies for probable cause on an alert by a drug sniffing dog, is required to present evidence to demonstrate that the dog is reliable, such that the sniff actually does indicate the presence of contraband. The evidence presented in this case fell short of carrying the Commonwealth's burden on that issue. There's no evidence in the record here that this dog and handler team were certified by what the Supreme Court has called a bona fide organization. No finding of certification at all. Now, there is testimony that was credited by the judge that they were trained, but there's no indication in the record as to what that training consists of, what successful completion of that training would mean. And there's no evidence in the record as to how this dog and handler team performed in that training. So that is the type of evidence that the Supreme Court has indicated would be most probative in the absence of evidence of certification.
Mr. Levin, I understand the argument, but doesn't that go to the weight rather than sufficiency? The judge entered a finding, and while there is certainly other evidence that could be more probative, it seems to me that with that finding, your obligation on appeal would be to demonstrate clear error on the part of the judge.
Well, I'm not sure about that, Your Honor. As to subsidiary facts, certainly the clear error standard would apply, but as to findings of ultimate facts, which I would suggest this essentially is, this court conducts an independent review based on the subsidiary facts that the judge found. So in this case, the subsidiary facts are the facts about the amount of training that the dog had and what the training consisted of. But the ultimate fact.
This is akin to the gatekeeping role that a judge plays on all manner of evidentiary questions going to the foundation. I understand words that subsidiary and ultimate facts may make a difference, but ultimately this is a matter that is ordinarily committed to the sound discretion of the trial judge as to the admissibility of evidence.
Your Honor, I'm not contesting the admissibility of the evidence. I'm contesting the sufficiency of the probable cause showing. All the evidence that was admitted is admissible at this hearing. That's not the question. The question is whether that evidence then adds up to a legal conclusion of probable cause. And that legal conclusion incorporates a conclusion that this dog is a reliable dog. It's essentially
this reliability of the dog raised in the motion to suppress?
Yes, Your Honor. The motion challenged the warrantless search of Mr. Judge. And so that obviously all warrantless searches are presumed to be unconstitutional. So the burden at that point is on the Commonwealth to show that probable cause existed for the search.
But there was nothing putting the Commonwealth on notice regarding specifically the reliability of the dog.
Well, Your Honor, I'm not. Well, in terms of putting the Commonwealth on notice, the Commonwealth was on notice. They called the dog's handler, and he testified about the training. And then there was a whole argument about the reliability of the dog. And then the Commonwealth briefed the question of the dog's reliability following the hearing. everyone understood that this was one of the issues to be litigated.
In advance of the hearing?
Yes, Your Honor, because Florida versus Harris requires a showing of a dog's reliability in order for probable cause to be found. It's exactly the same as asking whether a search that was based on an informant's tip, if a motion to suppress the evidence found in that search put the Commonwealth on sufficient notice that it had to establish the reliability of the informant. It's exactly the same question. And in fact, the Supreme Court in Harris specifically analyzed the dog's reliability through an analogy to an informant's tip.
Do you have any case where we or the Supreme Judicial Court have overturned a judge's finding of reliability based on an inadequate showing by the Commonwealth of reliability?
No, Your Honor. In fact, there are no published cases that I'm aware of since the Harris decision at all that address the dog sniff issue.
So what we've got is a presentation of evidence supporting reliability by the Commonwealth and a finding by the judge that the evidence presented by the Commonwealth was adequate in that judge's view to satisfy the Commonwealth's burden. And you're asking us to overturn that? Yes,
because as a matter of law, the evidence that they presented was not adequate.
Well, you say it's as a matter of law, but you're saying so without precedent to demonstrate that, it seems to me.
Well, Your Honor, the precedent would be Harris itself.
It says it identified the types of evidence that would be probative, but it doesn't establish that as a baseline prerequisite.
Well, I'm not sure I agree with that characterization, Your Honor. It says that the judge it says what types of evidence suffice to show reliability. And it clearly says that evidence must be presented that shows reliability.
Right. And we had evidence here that shows reliability. And you're challenging it because it doesn't check all of the boxes that were identified as potential mechanisms to do so in the Harris case. But again, I don't read Harris to establish a hard and fast bright line baseline. You're asking us to adopt that, and I understand the argument.
Yes, Your Honor. And so I would add, in addition to the requirements imposed by Harris, that the Harris decision, the probable cause analysis there is predicated heavily on the totality of the circumstances test adopted in Illinois versus Gates, which has been rejected by the SJC under Article 14. And so it stands to reason that Article 14 actually requires more of the Commonwealth than what is required under Harris. And some specific showing of reliability of the dog is required under Article 14, even if Your Honor does not agree that Harris sets this specific requirement forth.
No, I'm not challenging by any stretch of the imagination the premise that there has to be a showing of reliability. But I also think you have to acknowledge the Commonwealth did present evidence supporting reliability here, and the question is whether it was sufficient. The judge found that it was, and you're suggesting it wasn't.
That's right, and even just as a matter of common sense, the testimony that the officer does not keep track of his searches at all unless they turn something up. A court should not set a rule that encourages that type of record keeping, which would make it impossible to know ever if, in fact, the dog's alerts are not reliable in practice in the field. And so that's another aspect of this, that we know here, in fact, that the dog conducted several searches that this officer didn't recall and testified didn't happen, because we can see on the video the dog is inside of the car that the officer said the dog.
That's the same dog.
Your Honor, you can see the dog conducting the search of the first car, which the officer describes in his testimony, and then you can see the same dog moments later inside the other car.
Did anyone testify as to what the video depicted?
No, Your Honor, but the video was admitted without objection. and the court is perfectly capable of viewing it and drawing conclusions based on it. And I mean, it's plain on the video that it's the same dog and the same officer. You can see them.
But what do you want us to take from that video?
Well, so the video is more pertinent to my argument on the first issue. So I guess I would move to that at this point, which it shows that the officer O'Malley's testimony that the parking space on the driver's side of the Impala, where he said he had placed his police cruiser because that space was empty, the video shows that that space actually had another car parked in it. And it shows O'Malley's cruiser parked directly behind that car, which is in the parking space where he said he placed his cruiser. And then it shows that his cruiser is parked in such a position as to block the Impala's route from backing out of its parking space.
The defendant was not in the Impala at the time of that. If we were to adopt your suggestion that the cruiser's position effectively stopped the Impala, which was already parked, what bearing does that have on any seizure of the defendant?
So the bearing that it has on the defendant's seizure is that you have to consider the officer's actions, the totality of the officer's actions and the totality of the circumstances. And so although the defendant was not seated in the Impala at that moment, he had been seated in the driver's seat of the Impala.
No, but he's free to walk away, right?
Which he was.
Well, Your Honor, my contention is that that the officer's conduct put him on notice that he was not free to walk away by driving up, blocking the car that he had only moments ago exited the driver's seat of, thereby seizing that car's occupants with whom he had been socializing for the past hour.
But he had been socializing. He is not himself in the Impala, is not seized by the impediment of the Impala.
Well, his friends
may have been.
His friends are seized. He's still with them, and the rapid approach and by this officer in his cruiser, his marked cruiser, late at night, and his brilliant illumination of the whole area tells this defendant that he is not at liberty to just leave.
Are you saying that everybody was seized?
Yeah, everyone, all of those people were seized at that moment, and so and
then what about other people in the vicinity?
Well, there were no other people in the vicinity, Your Honor.
If there had been, I'm just trying to understand your premise, your principle about the effect of the officer's actions here. Not directed not merely to the vehicle, but to some area surrounding it.
So the effect was to seize everyone who was in this group of people. That was the effect of.
Were all the people specifically directed, stop, stay where you are? You're talking about just the action of pulling into the lot.
Yes, my argument is that even prior to the explicit order to stop, that the officer's actions showed that none of those people were free to leave.
What if the car, we frequently have situations where there is a very large group that's mulling about. And you're saying that a rapid approach has the effect, even prior to the issuance of any verbal directive, operates to seize all of the members of this group milling about.
Your Honor, I'm not making any arguments about a large group milling about a large space. You obviously have to take each case on its facts. And I'm saying that on these facts, where it's a small group, that we're not milling about a large space, but in fact, we're congregated around a specific car. That
the impediment of the car seizes not merely those in the car, but those who had been in the recent past.
Yes, the impediment of the car and in combination with the brilliant illumination of the area and the officer's rapid approach and the late night hour is also significant in the analysis I would submit. That how the people would view the officer's conduct depends on the totality of these circumstances. And so the fact that it was a small group of people who had been congregating, socializing around this particular car, has an impact on how all those people would view the officer's seizure of that car and its occupants in real time.
In terms of the chronology of events, you have very little time left, but I'm just curious, what do we know about when the order to stop, the verbal order, did that precede or follow the observation of the white powder in the console?
It's not totally clear from the testimony, and the judge doesn't actually really make an explicit finding about it either, but the order in which he lists the events is that he says that the officer saw the substance in the car, and then he says that the officer ordered everyone to stop. Right. And so that is my best interpretation, is that the finding is that it occurred in that order. And I do concede that at the point when he sees the substance in the car, that at that point there is reasonable suspicion for the stop.
Yeah. All right, thank you.
Thank you, Your Honor.
For the Commonwealth?
Good morning, Your Honors. Karen Palumbo for the Commonwealth. I'd first like to say that a motion to suppress must state the grounds with particularity. It needs to state all of the reasons, defenses, or objections available at the time. This motion to suppress was a very broad motion, which basically said that the defendant was arrested without a search or arrest warrant in violation of the Constitution. There was no indication in the motion to suppress or the affidavit that defendant was challenging the reliability of the drug dog. The rules of 13A2 is to put not only the judge on notice as to whether the defendant can meet his burden, but also to give the Commonwealth a notice as to which evidence to provide and which witnesses to call.
But this issue was engaged in the hearing. Go ahead.
But that really wasn't an issue here, because you knew that was going to be an issue. You had the dog handler. And so we really moved to the next step, which is you knew you'd have to prove the reliability of the dog. Is that right?
No, I don't believe that the Commonwealth did. I think that evidence that was presented was just evidence like foundation for the dog, for the officer and the dog doing the search.
Yes, but you know that you have to establish that foundation as part of your burden, right? I mean, that's a prerequisite. But
they didn't specifically state that they were challenging the reliability of the drug dog. And as defense counsel stated,
anytime you have an affirmative burden as a foundational prerequisite, you know that that's an issue, and it's up to you to establish an adequate foundation. The defendant doesn't have to state with particularity your need to swear the witnesses or do any number of other things to make your case.
Prior to the motion, the Commonwealth requested that at transcript 1 at 3, that the judge clarify the scope of the motion. Defense counsel said it's the stop, search, arrest, seizure. It's every step of the way. She never once mentioned that it was the reliability of the drug dog. But and the point being that if the Commonwealth was not on notice of it, as I suggest, the Commonwealth doesn't present the appropriate evidence. It's a circular argument. But defense counsel did not raise the reliability of the drug dog until closing. And when the defense counsel did, the court stated that nobody asked the questions of whether there were false positives or how many positive hits. Defense counsel had the opportunity to cross-examine the drug officer, and she failed to ask any of those questions. And I'm suggesting that because the Commonwealth was not on notice, they didn't present that evidence either.
So you're saying anytime a dog is used, it's presumed reliable unless cross-examination proves otherwise?
No, that's not what I'm suggesting at all. Had the defendant in the motion to suppress stated that he was challenging the reliability of the drug dog, the Commonwealth would have been on notice and would have been responsible, I believe, to put in evidence of the number of hits and the number of false positives.
For purposes of this hearing, let's just assume, we understand your argument on waiver, but let's just assume that we disagree with you as to the Commonwealth's burden absent a specific challenge. let's go on to the question of whether the evidence was sufficient.
Okay.
Your brother, you've heard his argument that Harris establishes a baseline of foundational prerequisites. How do you respond?
As counsel said, there's no case that specifically addresses this. The cases cited by defense counsel both deal with search warrants. In Santiago, which is a Superior Court case, the only information provided in the search warrant was that the canine was a trained canine dog, where there was no other information, and that was deemed insufficient to demonstrate the reliability of the dog. Defendant also cites Tecamo v. Ramos, in which the search warrant, the information provided was either intentionally reckless or false. So there was false information provided. There is evidence that the dog was reliable here. The police officer testified as to the number of hours of training. He testified to they train every single day. He's confident in his hits. They've gone through Alphys Canine, and every month they do a training. So I would suggest that that evidence is sufficient, and as the judge found, to demonstrate the reliability of the drug dog. And again, as the court said, it's the discretion of the motion judge, and the defendant has not demonstrated that he abused that discretion.
So is this very much like trying to establish, is it establish reliability or establishing expertise? Very much like a police officer who's got expertise in drug cases, and so you just lay out what their training and experience has been.
I mean, I think had it been raised, I think reliability comes from not only the training and the officer's experience with the dog, but it also comes with, you know, have they had false positives? Have they had, how many positive hits have they had? But I think there's sufficient evidence here. I don't think it's expertise for a dog. I don't think that would apply to a dog. I think it would be more reliability. And the judge did find, based on the evidence submitted at the hearing, that the dog was reliable.
What you just laid out is really more in terms of what was offered regarding the dog, was really in the nature of background experience and training, numbers of hours of training, daily training, monthly training. That doesn't necessarily equate to reliability.
Well, I disagree. The judge found that it did, but it circles back to the fact that the Commonwealth wasn't put on notice that the reliability of the drug dog was being challenged. Also, as far as reasonable suspicion, I'm not sure if the court, I'm sure you've reviewed all the facts of the case, but I'm suggesting that there was sufficient reasonable suspicion for the officer to approach. He observed a group of individuals around a known drug trafficker's vehicle. It was late at night in an area known for drug trafficking. He observed the defendant and Dos Santos engage in furtive behavior, reaching into the trunk while performing counter-surveillance, looking over their shoulder to make sure no one was looking. Defendant then entered the front seat of the vehicle. There is a question as to whether it was the front or the back seat, but he entered the vehicle briefly with the item that the Dos Santos had retrieved from the trunk. And then he exited the car without that item. At that point, police officer believed he observed a drug transaction. He had called for backup and was waiting for backup when he observed the group starting to disperse. He approached the group in his cruiser. And I would suggest that the point of seizure was not when he drove into the parking lot, but it was when he exited his vehicle, walked over to the group. As he walked over, he had his flashlight. And at the same time, he observed the white powder on the center console of the dash. And I would suggest at that point, the officer had reasonable suspicion, if not probable cause, to detain the individuals.
But you skipped over and in that recitation just now, you skipped over the point at which you suggest the seizure occurred.
I believe the seizure occurred. I apologize. I believe it occurred after he walked up toward the group, shone his light in the car, and told everybody to stop and put their hands either on the hood of the car or the dashboard of the car.
So your suggestion is that the seizure occurred at the moment of the verbal directive? Yes,
it was a show of authority suggesting that these individuals could not leave. I think before that, there was no suggestion that they could not leave.
Do you challenge the defendant's characterization of the position of the cruiser?
I do not. The video that was submitted, we have no idea when the video was began taping. There's
So you
no.
do challenge his description of the position of the cruiser.
Yes, Your Honor. The judge credited the officer's testimony regarding that. In the video, it's not certain. No one testified as to when it was done, whether it was edited. It's just not reliable video. And as far as the canine officer testified that he does an introductory sequence before searching individuals. He tells them what to expect. He asks them if they have anything on their person that they'd like to hand over. And he also asks them if it's okay to search. He said that he did the same thing, or he does the same thing with every individual. He did so with the defendant, and the defendant stated that there was no reason that he didn't have anything on him, and the defendant said, go ahead. So the Commonwealth would also suggest that the defendant consented to the search by the canine. And this court can affirm a motion to suppress on grounds other than that, which the court did if those are the preferred grounds and they're supported by the evidence.
Well, I just want to make sure I understand your argument. If we accept the suggestion that the defendant consented to the search by the canine, that doesn't get you past the question of the canine's reliability, does it?
It does.
How?
If he consented to the search, then there was consent, so the officer doesn't need to prove that the dog was reliable.
No, I mean he consents to the dog, but he doesn't endorse the validity of the dog's findings.
Well, consent. If someone consents to a search, then that search is valid. So
if somebody consented to a search and the police find drugs, does that amount to a concession that the analysis of the white powder is valid?
I'm not sure what you're saying, but if they had contested whether or not he consented in the motion to suppress,
no, but no. I guess my point is this: he consented to the canine. He didn't consent to the strip search.
Okay.
And the strip search.
No.
The strip search rests on the result of the canine. So he can consent to examination by a dog, but he doesn't, in so doing, consent to to taking any action based on what the dog does, unless we establish what the dog does is reliable.
Okay, I understand. I apologize. So yes, so I do believe he consented, but then he was brought back to the station and a strip search was conducted. So I would suggest that the judge's findings of reliability suffice where the defendant has not.
Right. So, I mean, we're still back to the same question. He can consent to the use of the dog, but he doesn't. But his consent does not get you past the question of reliability, and you have to rest on the showing and the judge's finding.
Yes, correct, Your Honor.
Okay.
If the court has no further questions, I'd rest on my brief. And also, I would just like to thank the court for being so accommodating.
Well, we hope everyone is well and continues to be so. Thank you.
Thank you.
Thank you both. The case is submitted. We are in recess.
Okay, thank you, Your Honors.